Ladies and gentlemen, ladies and gents, got a little bit of Billy Joel in my background. He's actually in my foreground, and he's talking about somebody having a way. And Billy Joel, a legend. And so, Billy Joel, everyone. Ladies and gentlemen, I got something I want to talk to you about. Okay? We talked last night, and we're going to start this because it's on pause. And it shouldn't be on pause. It says it's not on pause, but it was on pause, so let's see if we can resume it. If not, we'll just have to look at it being on pause. And it shouldn't be that way. So while I'm correcting things in the background, I'm going to chit-chat with you guys for a minute. We got a couple of things that we're going to talk about. As a matter of fact, I'll be right back, okay? So that we can talk. Okay, ladies and gentlemen, I had to get a couple of things ready. Because I got wind in the background, and I know it's blowing on the speaker, and I'm going to have to put something in between. It was 91 degrees, it's 89 degrees now, so the wind, this is a normal thing for this time of day. I apologize that I am trying to put up something to shield y'all from the wind so that y'all don't get all that wind noise. So I apologize. Ladies and gentlemen, I had to get things ready for the conversation that we're about to have. Over the next couple of weeks, we're going to be solely talking about tax credits. There are some other documents that I do have to do. I was just going over the non-appearance document. I'm going to suggest that you guys understand what appearing is. When they have you all rise, you may be seated. Your Honor, appearing before the court today is Mrs. Crabtree, and she's representing the people. And appearing for behalf of the defendant is John Rockenberger, and John Rockenberger is representing Mr. Rockinsam. Mr. Rockinsam has been accused... Oh, well, I'm sorry, I'll let the public defender tell you, Your Honor. Thank you. Okay. When they say you're appearing in court, that means you're submitting to the court's jurisdiction. Ladies and gentlemen, how dare you submit to the court's jurisdiction when subject matter jurisdiction may be challenged at any point in the proceedings, even on appeal. And I apologize, we ain't supposed to be having no music. Y'all see that? It's a celebration! Celebrate good times! Come on, y'all! I'm supposed to take down the music, but we are going to go ahead and just pause it. No, we're going to let it play. Y'all need to be able to see some spectaculars. Yay! Yes, it's a backtop. I can actually put a movie in, and the movie will become this right here. I like the program, y'all. So let's go ahead. We're going to stop it for now. We'll come back to it. There you go. That looks pretty all right. Ladies and gentlemen, let's get back to those of you who have proceedings in court. Challenges to the trial court's subject matter jurisdiction may be raised at any time, even on appeal. Now, you don't want to just do subject matter jurisdiction, because they'll claim that there's a statute and the statute governs this, and so we have jurisdiction. So you don't want to do subject matter jurisdiction. You want to do personam jurisdiction. For instance, we have a case in Mississippi. Mississippi is using what's known as the long arm statute to bring us into that case. But hold on, there's no proof or any evidence that we were actually associated with anything in that case in Mississippi. Mississippi is not even our headquarters. So why are they bringing us into Mississippi? Interesting, ain't it? They even brought me into Mississippi. Ladies and gentlemen, I've only been to Mississippi a couple of times. Every time I've been to Mississippi, it's driving right through. I think one time I actually stopped that I can recall. Well, you already have a bad memory, so you shouldn't even be talking about recalling something. You know what? I'm going to recall you. It's right on outside that door. You better be gone. Maxwell is asking somebody to stop the world, y'all. Ladies and gentlemen, you challenged jurisdiction right off the bat, without hesitation. What jurisdiction are you challenging? You sit up there and figure it out. No, sorry, you don't have to do that. You basically say, I'm challenging every aspect of jurisdiction, so go ahead and start proving it. And I don't want to hear no words. Words don't prove nothing. I don't want your presumptions. A jurisdiction cannot be presumptive. Jurisdiction has to be factual. How do you know jurisdiction has to be factual? Because I just said it, you ignorant mother... Okay. It is true that the question of subject matter jurisdiction can be raised at any time, in any manner, even on appeal. Okay? Why? Because there is one thing in here that says that the court has to continue to deal with whether or not it has jurisdiction. It has to do it in the background. Look, we agree. Subject matter jurisdiction is a prerequisite to the exercise judicial authority over any case in controversy. So I think it might be this one. No, this says that the parties cannot agree to the court's lack of jurisdiction, so the parties can't consent. Well, if you lack jurisdiction, Your Honor, we're going to give it to you. We're just going to let you just decide because we want to hear it from you. Okay, it cannot be waived and it cannot be consented to by the parties. Arrest was facially invalid for failing sufficiently to describe the victim's identity. The issue of subject matter jurisdiction may be raised at any time, even on appeal. Okay. Let's see. Oh, and you know what? I understand this case just by reading. It says that he has a right to face his accuser. So his arrest was facially invalid, failing to sufficiently describe the victim's identity. So they denied him the right to confront his witness because when he was arrested, all that information about who the victim was supposed to be part of the warrant. Okay? Give me 1 second. I'm trying to look for the one where it says the court has to continue to examine whether or not it has jurisdiction. And I may not find it this quick. Nope, still subject matter. The trial court subject matter jurisdiction is a question of law, no de novo. See, de novo means without anybody present. Judges hearing it based on, that's how most appeals are done, is de novo. Okay? Challenge to the courts, including on appeal. Subject matter, nope, sorry, can't find it. I thought I'd be able to find it. That how the courts say that the court should continuously be going over whether or not it has jurisdiction all throughout the proceedings. It says that is the court's duty. And I have it, I put it in one of our documents because we're responding to the court. See, we're still challenging the court's jurisdiction. We're not letting that go. Ladies and gentlemen, hold on, I'm going to pause you guys for just a second. Okay, ladies and gentlemen, I decided to let the video play out and then come back to you to tell you what I was going to talk to you about. I got an email this morning. I actually got it last night, and I answered and responded to it this morning. There was a guy talking about being involved in foreclosures and going over his history with foreclosures, and I just want you all to understand something. I didn't ask. Literally, I didn't ask him about his history and what he was going through. It's not my business. Well, he first started off the conversation by saying I had it all wrong. Well, what did I have wrong? He said you can't use UCC in foreclosures. Ladies and gentlemen, what the flying fart. Hold on. Now, I want you to know, this is what he says. He says he's been doing this stuff, not the foreclosure stuff. He was a part of the banking industry for some odd years, and he's been doing this stuff for 40 years. Because I made a comment about how I've been officially doing this law stuff for 35 years. So he had to one-up me by saying he's been doing it for 40 years and he's retired. Well, then that means you ain't doing it for 40 years. You retired, mother... Okay, anyway. Ladies and gentlemen, watch this. UCC 9. I'm just going to put, uh-oh, it jumped. Dang it. It wasn't supposed to jump. Let's, it ain't going to let me bring it down, so I got to just delete it. Okay. Well, will it here? Yeah, it will let me bring it down. Uh-oh. It didn't let me bring it down. Yeah, I just did the same thing. Sorry. No one ever told us. Okay, and foreclosure, RIGHTS of BORROWER. Foreclosure rights of borrower. Can you mend a broken heart? And Tammy, come on, mammy. How can you stop the rain from falling down? Does anybody know? Tell me. How can you stop the sun from shining? What makes the world go round? Centrifugal force. And it's just the effects of gravity, centrifugal force, and the gravitational pull of... Oh, I'm sorry, you didn't want to know that? My bad. Alright, I didn't think he was asking that, but it sounded like he was asking that. Wait, hold on. Did y'all see that right there? See Trump on the ocean, LLC. See Trump on the ocean, LLC. Interesting, huh? UCC Article 9, Part 6 governs non-judicial foreclosure on cooperative apartment loans. Ladies and gentlemen, that person told me UCC had nothing to do with foreclosures. Excuse me. Section 9 was created specifically for foreclosure and housing contracts. UCC 9 covers the stupid contract, the mortgage agreement, that junk, that deed of trust. That's under UCC Article number 9. That's why it was created. I apologize. The person told me I didn't know what I was doing and what I was talking about. That's why I decided, hold on. The strict foreclosure remedy is codified in UCC 9-620 and UCC 9-622, which appears in UCC 9, Article 9. Look at this. The strict foreclosure remedy. Ladies and gentlemen, I don't know what the strict foreclosure remedy is. You guys think we should check it out? Well, I haven't looked at this case before. I'm just showing it to him for the first time. Well, I think we should check it out. But what if it doesn't say something important? We just wasted a lot of time. I still think we should check it out. It can't hurt, can it? Well, it can only waste your time, and you talk about how you don't have that type of time. But we're doing this for the people, so I think we should check it out. All right, you go ahead and check it out now. Okay, ladies and gentlemen, let's check out this case. Because somebody told me that UCC has nothing to do with foreclosure. And he's got 40 years experience. And he's retired. I apologize, ladies and gentlemen. Like I said, I begged people to prove me wrong. But instead of people proving me wrong, they come at me with ignorance. Hold on. There you go. Okay. Hey. It's going to be in our background. Oh, we're going to talk about full faith and credit in a minute, okay? Now let me get back to foreclosure. Oh, come on. Oh, okay. You know what I did? I apologize, y'all. I clicked on the 9-620. This is... Now, the reason why it's 9-620 because it's New York's foreclosure. Acceptance of collateral and full or partial satisfaction of obligation. Compulsory disposition of collateral. Ladies and gentlemen, you all are going to need to have 9-620. Remember, that's all we've been talking about is collateral. Ladies and gentlemen, I want you guys to pay attention. That's all we're going to be talking about is collateral. and your right to pledge portion of the collateral. So go and look up not UCC for New York, but UCC 9-620. All right. Conditional acceptance and satisfaction, except as otherwise provided in Section G and H, a secured party may accept collateral in full or partial satisfaction of the obligation if it secures only if the debtor consents to the acceptance under Section C. The secured party does not receive within the time set for such in Section D a notification of objection to the proposal of the authenticated by a person, what type of person? To which the secured party was required to send the proposal under Section 9-621. Or, this moment, ladies and gentlemen, this is the Jacksons, and they're talking about Daddy's home. Any other person other than the debtor holding an interest in the collateral subordinate to the security interest that is subject to the proposal. If the collateral is consumer goods, pay attention. I want you guys to pay attention because I just saw this and I would not have picked up on it otherwise. We're looking at this condition of collateral. Conditions to accept and satisfaction and accord, except as otherwise provided in G and H. A secured party may accept collateral in full or partial satisfaction of the obligation only if, let's go down, where we were. The collateral is consumer goods and the collateral is not in the possession of the debtor when the debtor consents to the exception. Okay? The collateral is consumer goods. The collateral is not in possession of the debtor when the debtor consents to acceptance. If the collateral is in possession of the debtor, they cannot do it because it's consumer goods. Shh. Look up the definition for consumer goods. You'll find it in 9 U.S.C. section 102 and 109. Look up the definition for consumer goods. Subsection does not require the secured party to dispose of the collateral or the debtor waives the requirement pursuant to 9-624. Purported acceptance is ineffective. A purported or apparent acceptance of collateral under this section is ineffective unless the secured party consents to the acceptance in an authenticated record or sends a proposal to the debtor. The conditions of subsection A are met. The debtor consents, that's when those conditions are met. The debtor consents for purposes of this section. The debtor consents to an acceptance of collateral. Oh, I think we're going to get in some trouble right here. The debtor consents to the acceptance of the collateral in partial satisfaction of obligation it secures only if the debtor agrees to the terms of acceptance in the record authenticated after the default, not before. The debtor consents to the acceptance of the collateral in full satisfaction and accord of the obligation to secure. It secures only if the debtor agrees to the terms of the acceptance of the record authenticated after the default, or the secured party sends to the debtor after the default a proposal that is unconditional and subject to no conditions, that collateral is not in possession of the secured party, be preserved and maintained. Ladies and gentlemen, this is what happens when they're getting ready to foreclose on you, and they do foreclose on you. Then they send a notice to you letting you know you need to vacate. They're about to take possession of the property, and you voluntarily vacate the property. Okay? And their proposal proposes to accept collateral in full satisfaction obligation secured and does not receive notification of objection to authenticate by the debtor within 20 days after the proposal is sent. Effectiveness of notification. To be effective under these subsection, a notification objection must be received by the secured party. In the case of a person to which a proposal was sent pursuant to section 621, within 20 days after notification was sent to that person, and in other cases within 20 days of the last notification that was sent pursuant to 621, or if a notification was not sent, before the debtor consent to the acceptance under this. All right. ladies and gentlemen, again, we are talking about collateral. So everybody will presume that this deals with homes alone, only. No. Mandatory disposition of consumer goods. A secured party that has taken possession of collateral shall dispose of the collateral pursuant to 9610 within the time frame specified, if 60% of the cash price has been paid in the case of a purchase money security interest in consumer goods, or blah blah blah. Okay, I'm definitely going to suggest you guys go over this. The best way to go over this is, if you have a situation, go over it, find the key words. Remember, it says acceptance of collateral. So watch this. Hold on. Copy. Now I do Control F, because we're going to do, we could do a search this way by me clicking here. And watch this. I'm going to get rid of that. And I'm just going to paste that there. And that's it. Now it finds that phrase 6 times. So if I find a phrase in here, I can look up that phrase and every single time and pay more attention to it. Purported acceptance is ineffective. A purported or apparent acceptance of collateral under this section is ineffective unless, so pay attention, it says it's ineffective unless these things happen. If these things don't happen, it's ineffective. If these things do happen, then it's not ineffective. They did that on purpose, ladies and gentlemen. This is legalese. So it makes it seem like it's ineffective if these things are the case. But no, it says it's ineffective unless the secured party consents to the acceptance. So if the secured party doesn't consent to the acceptance in an authenticated record, and sends their proposal to the debtor, it's ineffective. Okay, there you go. Now, we are not going to pay attention. Stay on this. This was just somebody telling me that the UCC does not apply to foreclosures, does not apply to homes. What you talking about, Willis? I guess I'm wrong and these court cases are wrong, and all of Article 9 is wrong. Because the person doesn't know. Okay, sorry. Let me show you guys something about UCC 9. HISTORY. Let's just do that. This book, chapter, traces the history of Article 9, secured transactions. Ladies and gentlemen, pay attention. When I tell you again, it is not a secured loan because you did not own the collateral. That means, pay attention, they cannot do the foreclosure because the Non-Judicial Foreclosure Act, the same foreclosure act of your state, they go harmonizing because the Uniform Commercial Code was designed to uniform the laws in America with respects to commercial transactions. That's what the Uniform Commercial Code deals with, is commercial transactions. That's why it's called the Commercial Code. I apologize. Sorry, somebody had to speak out the side of their neck that I didn't know what I was talking about. Okay, telling me, well, that doesn't work. Ladies and gentlemen, I've been hearing the defeatist attitude for too long. That doesn't work. 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 That somebody hit them in the back of their head so they can talk about something else. Ladies and gentlemen, can I explain something to you guys? I think you will understand this and I think you'll get it. I don't care. You know what, Snoop? You gotta go. No, me and Snoop, we okay and everything. I'm not in the mood right now for Snoop. You know what I'm saying? Just me and Snoop. And that wasn't no cursing or anything. I just ain't in the mood for Snoop right now. Snoop is alright and everything, because, you know, I know all's about the chronic. Okay? But not right now. Look. We're going to go here. After setting out the pre-1940, okay, there was a lot of work that went into Article 9. A lot of lawyers got involved in this because they had to make sure of some certain things. Okay? Traces the history of Article 9 secure transaction United States Uniform Commercial Code. All of the countries that are involved in the, what's the name of that stupid thing? Get out of here. The World Trade Organization. They have a Uniform Commercial Code that pretty much harmonizes with this junk. Let's pay attention for a second. After setting out the pre-1940 legal settings in the United States for the use of movable property in secured transactions, the chapter studies 3 stages of evolution of Article 9. Drafting of the first article, continuing revisions of the text, and it shows adoption by states, and the thoroughgoing revisions that led to the present 1998 official text and subsequent minor amendments in 1990 to the present. The chapter notes the growing complexities of the text and the importance of institutional framework that the text involve. Okay? We're not going to read no book. What I'm just trying to show you is when you do the research, you'll see that specifically they claim it was because of the confusion of mortgages. This is the reason. Article 9. And remember, it was secure transaction, not just movable. That's why if you go and you take a look at New Hampshire, the right to travel law, go ahead. New Hampshire has a right to travel law. It's called House Bill 1778. New Hampshire has a right to travel law. Go and look at it, and it talks about Judge Grimes and the purpose of the act. If you go and look at Judge Grimes and what Grimes had to say, it was a movable vehicle, an automobile that case was about. And that's where he talked about, pay attention, people. He talked about household goods, consumer goods being non-taxable. So I'm only speaking about this because had I spoken about it to you guys, you wouldn't know. But the individual contacted me and he CC'd 2 other people. Again, because he had something he wanted to prove, or he was going to set something straight, and I don't understand it, ladies and gentlemen. It don't make no sense to me. Okay? Sorry. Somebody emailed me and asked me for some advice on something. And I basically told him the information that he was talking about, he might as well have asked for a consult because that's the information he was looking for. But I gave him information on what he should do if I were in his shoes. Okay? We got a lot to talk about, ladies and gentlemen. Had the individual who wrote that email not CC'd other people so that he could notify them what he wrote to me about, because he's more interested in being right. Ladies and gentlemen, I don't care if I'm right. I don't care if I'm wrong. My job is to help you. It's not about being right, but I have to be right because I can't give you false information. So somebody was implying that the UCC did not apply to mortgage. Hold on. Now, he didn't say Article 9. He said, see, UCC 9 doesn't work. I like that. UCC 9 does it. APPLYTOMORTGAGEAS. We're going to do this one. We're going to do it the way they wrote it. Article 9 applies both to security interests and security interests. Article 9 applies both to security interests. Article 9 applies both a security interest in a mortgage note and to secure an obligation and to the rights of the buyer of a mortgage note. Okay? Ladies and gentlemen, pay attention. Generally, the seller or the person creating a security interest to secure an obligation must authenticate the security agreement described in the mortgage note. The reason why they have to do this, pay attention. reason why they have to authenticate it by putting it on the record, the reason why they have to authenticate it by putting it on the record, getting it notarized, is because they need approval. They can't just take your interest and market it and do all that stuff without your approval. Okay? So, but again, look, Article 3 and 9 of the UCC are relevant to mortgage loans. I didn't write this. It's not me writing this stuff. Now, look, although as a general rule, Article 9 does not apply to transactions involving real property, collateral, or borderline between real property and personal property. See, as a general rule, sorry, general rule doesn't work. It's a commercial transaction. It's secured property. Generally speaking, Article 9 applies only to transactions involving security interests. That's why they need the collateral, because the collateral secures the interest in the property. Shh. Well, that means he was partially right, wasn't he? No, because he said it didn't apply to mortgages at all. He didn't say Article 9. He said UCC didn't apply to mortgages at all. As you find, right, where you at? Where you at? Right here. If we go here, and I don't know who Baker Donaldson is, but it's BakerDonaldson.com. So apparently he's a mortgager. Okay? Mortgages in UCC. This is 2012, ladies and gentlemen. I don't know who this is. I don't want you. No, I don't want you. Hold on. All right. I didn't mean to do that. I apologize. All right, let's go. Get rid of y'all. Okay, get on out of here. Go play. Who is entitled to enforce a mortgage note? How can the owner of a note effectively transfer ownership? What is the effect of such transfer? Ladies and gentlemen, I'll give him a little bit of credit. I don't know who this is, but apparently it's the company. Okay? I don't know. So let's find out. Professionals, practice. Okay? So they're a lawyer, huh? I don't know. Can't tell you. Our firm. Oh, it looks like they're lawyers. Talking about their firm. Firm profile. For 130 years. You're sure it's not 40 years? 130 years. Baker Donaldson has built a reputation of achieving results for our clients, both nationally and internationally, with a wide range of legal matters. No, I don't know all the attorney firms out there. I apologize. I know it seems like I should, but no, because attorneys and starting up a law firm is a dime a dozen in this country. Okay? I know about Larry H. Parker. My friend used to date his daughter. See, that's how I know about Larry H. And Larry H. Parker got me $1.2 million. Didn't say the guy was in a wheelchair. Shh, don't tell nobody. Okay, see what I'm saying? So, somebody challenged me. Said I didn't know what I was talking about. Again, how many times do I have to do videos proving to you that I don't talk about something that I don't know? People ask me questions all the time. Somebody asked me a question today. Called me up less than an hour ago, y'all. And he says, look, I'm calling to ask you about this. And I had to tell him quite literally, I don't know about that. Really? You don't know about something? You better believe it, and I'm not afraid to admit it, people. I'm not here to mislead nobody. I'm here to give you information. I'm here to give you information that you're going to take that information, you're going to do your own research. So pay attention. Article 9 applies both to a security interest, to secure a loan, and a buyer's right in the mortgage note. Why? Because, pay attention, his right to the mortgage note, because he has a security interest. It applies to security interests. Secure loans. Security interest to secure an obligation. So, again, this has nothing to do with somebody telling me that I was wrong. This has everything to do with he didn't know all the facts. Go ahead and go back and listen to see. Now, I think there was one time I had to come back and tell you guys, but even when I told you it, I said, but no, here, when you look at it this way, I'm 100% right, and you got to do this in order for this to happen. Because in an hour's time, you can't explain all aspects of law to people. Okay? I just don't have that ability. Okay? All right. Ladies and gentlemen, you ready for some tax credits?
I'm ready.
You're not ready.
I am.
No, you're not. Moron.
I'm not more. I'm less Ron. Moron is my brother.
Ladies and gentlemen,
There's another background.
we're going to talk about full faith and credit.
Full faith and credit. Man, I heard about some full faith and credit.
You've heard about full faith and credit.
I told you I done heard about some full faith and credit.
Well, what do you know about full faith and credit?
Well, I know it's full of faith. And man, I met credit. But that fool, he can't be counted on.
So, you met credit.
Man, I met credit and I hung out with credit. Man, we kicking buddies. You know, we just kicking. Like SUV and SWV and you know what I'm talking about. Escaping. You know, just kicking it.
Really? Escape did the song Just Kicking, and you decided you're going to play on words.
Man, what you don't worry about what I'm playing on. You go ahead and finish telling these people about full faith and credit, because I'm interested to learn about that too.
Okay, ladies and gentlemen, what is full faith and credit? Anybody? Pay attention. Full faith and credit is a phrase. It's legal terminology used to describe one entity's unconditional guarantee or commitment to back the interest or principal of another entity's debt. Ladies and gentlemen, the government is not the only one who has full faith and credit. You have full faith and credit. Shh! Don't tell nobody about that. Man, somebody's been saying this since 2012, and they even put it on these things called our style money orders, that it was backed by credit. And they did this video. It was called Hyben, the Credit Monster. Okay? Can't find the video no more. I don't know what happened to that video, but he explained that everything was based on credit. Ladies and gentlemen, all of you have full faith and credit. It is your combined full faith and credit where the United States gets its full faith and credit. Let's see if that's true. The full faith and credit commitment is typically employed by a government, typically, but not universally, to help lower borrowing costs of a smaller, less stable government or a government-sponsored agency. Full faith and credit is an unsecured method of backing a debt based on trust and reputation. Full faith and credit is an unsecured method of backing a debt based on faith and reputation, trust and reputation. Ladies and gentlemen, let me show you something. When you go buy a home, you're interested? Well, we're going to have to run a credit check. I don't care. Okay, we're going to need your employment history. Okay. We're going to need your banking information. Okay. And we're going to need some blood from your wife. From who? Okay. You give them all the information. All right. We got to send it to underwriting. They're going to approve you. If they approve you, you get what you get. If they don't approve you, ain't getting. All right, fine. Send it to underwriting. Ladies and gentlemen, it goes to underwriting. Hey, your loan funded today. My loan funded? Your loan funded. Why? Because your loan was backed by full faith and credit. It's an unsecured loan. Based on your reputation, because you just told us about your credit worthiness and we ran a credit check. Governments offer or issue bonds backed only by their ability to collect taxes and other revenue in the future. So when governments are issuing bonds, they're doing it based on your contribution, which means you have an interest in the full faith and credit of the United States government. Shh! Because governments theoretically have an unlimited and unlawful I know it says lawful, unlimited and unlawful capacity to collect revenue. These bonds are often considered low risk and thus carry low yields. The government's National Mortgage Association, Guinea May, Guinea, come here, Guinea. You're a cute little guinea. Is one example of a government-sponsored agency that is backed by the full faith and credit of the United States government. Now, understanding full faith and credit refers to the full borrowing power of the government to pledge. Remember, you can pledge full faith and credit because you have an interest in the collateral. Go back and look up a borrower's interest in the collateral. Pledge to fulfill its payment obligation in a timely manner. The United States Treasury issues bills, notes, and bonds as a means of borrowing money from the public. Hey, John Q. Jane Q. Where y'all at? John Q. Public? Jane Q. Public? Public? Where you public? You member of the public? Okay, well, they borrowing money from you as a means of borrowing money from you, the public, to fund the government's capital projects. I'm going to click on here because I'm interested to see what it says. Oh, we've already been here before. Okay. Treasury Direct reads investment articles, bills, access. Okay, that's when I last access. Okay. Let's continue, shall we? Where were we? We're not going to read everything. We're going to finish reading this. These securities require that interest payments be made to lenders and investors periodically. On a maturity date, bondholders expect full payment on the face value of their securities, or their SatPacks. But see, a maturity dates, they expect the full payment. Well, we're going to be accelerating that maturity date. Just pay attention. To encourage investors to purchase debts issued, the treasuries are backed by the full faith and credit of the government, provide assurances to fixed income investors that the expected interest payment and the principal payments will be made regardless of economic situation. Ladies and gentlemen, our credit is based on the full faith and credit of the United States government. That's where the tax credits come from. The full faith and credit of the United States government. It is the same as if an individual went and bought a treasury bill. You don't believe me? Go back and do your research on how tax credits work. These are not state-issued tax credits. These are federal tax credits. Go ahead and look at when the federal tax credits expire. Okay? Because treasury securities are backed by the full faith and credit of the government, they are referred to as risk-free securities. The government cannot default on its obligations. Why not? As it has the power to print more money and increase taxes in order to pay its debt. The government cannot default on its obligation as it has the power to print more money and increase taxes in order to pay its debts. Can I tell you guys something? We're going to go to a website. We're going to do 521. So we're going to do average gas prices 521. Did I do average wrong? Of course I always do. I have no idea why I do. Oh, because I pronounce it average. Okay. Weekly U.S. regular all formations. Retail gas prices. So this does weekly. Now this goes all the way back to 1990. Now if you guys are not familiar with 1990, 1990 gas prices went all the way down to, I think it was almost like 84 cents a gallon. This was the average. Okay, But we're not talking about way back then. I don't want to go all the way back then. But this is a price by price. So let's go here because we're looking for the price of gasoline at the beginning of this year and now. Because we need to show you something.
Let me show you something.
Okay, 91, 92. And you can see, come on now. We got to get all the way up to 2020. Uh-oh, I done lost it, y'all.
Oh, mama, he done lost it again. That boy ain't never straight. That boy he just, ooh.
Now see, 2013. Take a look at this, 2014. Now, what I need to do is I didn't look to see what the other numbers were, so I got to go all the way back up to the top. Because we made it to from the bottom, now we made it to the top, you know. Okay. No, got to go this way. Now, you see that 2020. You see this drop right here? $1.77. And now, $3.45. But let's go right here. Remember I said right about, this is $2.85 a gallon. In April of this year. I'm paying over $4.30 a gallon, and I'm not in Los Angeles. Now, do you know why gasoline is almost twice as much? Anybody? Well, let me show you, if you don't mind.
Let me show you something.
The government cannot default on its obligation, as it has the power to print more money and increase taxes in order to pay its debts. So gas prices are not going higher because gas is more expensive. Pay attention. This was October of last year. October of last year. Well, the pandemic was going on. It doesn't matter that the pandemic was going on. This was almost a year ago. It's September now. This is October of last year. Let's do a year ago. That's July. We're going to go to September. September was $2.16. Last year, I said I was paying $4.30. $2.16, $2.16, $2. Twice as much, people. Twice as much as a year ago. There was no reason for it. Well, they said that there was an attack on some refinery. Yeah, that attack's been over with for months. Well, then you also have the summer. No, this is September. Summer's over. Well, you got to remember, this is the holiday weekend, and gas prices go up because of this holiday weekend because everybody traveling. That's right. But gas prices aren't supposed to be staying this high. It went up 60 cents as a result of that refinery issue. Ladies and gentlemen, because nobody pays attention to this stuff, they did this and you all accepted it. That it was somebody attacking some refinery on the East Coast, which caused all the gas of the entire nation to go up. You fell for that, didn't you? One refinery, like we only have one refinery in the United States. One refinery could cause all the gas throughout the entire nation to go up by 60 cents. Ladies and gentlemen, we are almost 70 cents since that incident. The reason why that has happened, pay attention, because some of you are not paying attention. What happened in September? Did they not just get through one stimulus and was getting ready to do another stimulus? Well, look at what happened with the stimulus. Look, ladies and gentlemen, this was October, and they did 2 stimulus since then. And look at what happened to gas prices. Because what happened? The government can just print more money. Unlimited. See, they cannot default on their obligation because they have the power to print more money and increase taxes. But I thought President Trump decreased taxes. No, he didn't. Ladies and gentlemen, when they do inflation, pay attention, that raises taxes because the tax rate goes up with inflation. So you end up paying more twice. You end up paying for the inflation, and then you end up paying higher taxes because of the inflation. They understand how to do double taxation. So, just wanted to explain that to you guys. I dare anybody to correct me on that one. Gonna tell me gas prices went up because somebody sneezed yesterday. I'll believe that in a split second. Now, debt issued by smaller government entities, such as a municipality, your city, that's what municipality stands for, municipality, may also have full faith and credit of the issuer. General obligation, municipal bonds. This is what courts and other state agencies invest in. Is general obligation municipal bonds. California was very good at that. Yep, lost so much money. They are payable from the municipality's general fund. Where did the general fund comes from? The people's taxes. And are backed by the full faith and credit of the municipal issuer. The people's taxes, which may have an unlimited authority to tax residents to pay bondholders. You see, the city taxes you to pay their bonds, which they do the faulty investment in. This is where government does not have the right, pay attention, government does not have the right to gamble with the people's monies. So the people vote on what's known as bond initiatives. So the people give the government permission to gamble with their monies. And they wonder why cities like Detroit go bankrupt. They wonder why California's in a hole. The second largest economy in the world, California. The second largest economy in the world. And it faces deficits. It doesn't have a deficit now. Everybody want to talk about Newsom. Now, I don't vote. But they want to talk about Newsom. California's not in a deficit. When he first came in, it was. So the idiot must be doing something. I know, you can't give him the credit, okay? He doesn't get the credit. He's just one man. He's the chief of the helm. So when something goes wrong, he has to take the full blunt of the... That's what he get. Knew the job was dangerous before he took it. On rare occasions, the federal government may step in to back a portion of the payment of obligation of municipalities by its full faith and credit. Yes, and charge them for it. They'll step in, all right, but they'll also step on the neck of that municipality. That's what happened to Detroit. Why do you think they poisoned the water and gave people poisoned water? What do you mean they didn't poison the water? Wait, you mean to tell me that they didn't have water coming through old pipes on purpose into the city? You all thought that that was Emmanuel and all them doing that? Please, that was the federal government doing that. That's why Barack Obama went out there talking about he was drinking from a cup of water. Okay? Talking about the water was fine. That's what happened to Puerto Rico. When Puerto Rico, remember HARP? Remember HARP? When Puerto Rico, do you remember HARP? Ladies and gentlemen, let me show you how the government, how much they hated Puerto Rico. Let's go here. Ladies and gentlemen, this is Darius. And Darius, I like Darius. Even the country, that's why I downloaded 2 of his albums. Because I think he did all right with that. H-A... Okay, I don't want the HARP plane. I didn't know anything about a HARP plane, though. I did not know about a HARP plane. Okay, let's do this right here. We're going to do the HARP project to let you guys know. Hey, I know some of you already know about this, but there are a lot of people who do not know about the High Altitude Research Project. Okay? There are a lot of people who don't know about this. They don't know that they can use this technology to control weather. Okay? High Frequency Active Auroral Research Program. HARP. It's AARP. So HAARP. Sorry, I did it wrong. So I apologize. Now watch this. Hold on. I don't want that one. I don't want India. Well, because all the governments got involved in the same thing. They all did research, and that's why you see the floodings and everything happening. They use it for warfare. Okay? They utilize HARP for warfare. It's what the governments do. Don't know why they do stupid things like that. Okay? And watch this. PUERTO. Do I have to finish? Okay. RICO. Heart in Puerto Rico. Arecibo! 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 Puerto Rico! This is, you remember that dish? I lived about 50 miles from here. I used to pass by it all the time going to San Juan. Arecibo. Okay? Ladies and gentlemen, that dish that the cable broke, yeah, right. That was because the United States government decided that Puerto Rico wasn't handling its finances correctly. Hold on. When a municipality is not handling its finances correctly, the federal government steps in. They could have saved that dish, but they decided, man, that's Puerto Rico. We ain't doing nothing for them. Remember what happened in Hurricane Maria? They did nothing. The federal government did nothing. Don't tell me that they did a little bit. They didn't even do a little bit. They left those people to suffer. Why? Because this government debt thing is a big thing. It's not a small thing. This government debt thing is a big thing. Ladies and gentlemen, I have this this app called what is this thing? iHeartRadio. And what happens is I have a bootleg version, a modified version of the app. However, the modified version of the app literally says no commercials. The only problem with the no commercial thing is when you skip a song, the commercials come on. They'll come on whether or not you have it turned off or not. And so what I did is earlier I skipped the song with Snoopy, and when I skipped the Snoop Doggy Dogg song, it wasn't just him, it was a mix. When I skipped that song, the commercials said, "What up, homie?" And so that's why we had commercials. So I apologize that we had commercials. I don't like commercials. I don't want nobody trying to convince me to buy anything. If I'm going to buy something, I want to choose it for myself. I don't want nobody influencing me because I don't want to be influenced by nobody. Is that okay? And so that's how I live. Okay, getting back to full faith and credit, because this was just letting you know, for those of you who even think that somebody doesn't even know about finances, the other thing besides the law that I was fascinated with, I told you, when I heard that Donald Trump was filing for bankruptcy, and he's filed several times for bankruptcy, I said to myself, that's stupid. He must be stupid. How can you be a millionaire and go bankrupt? If you lose $100, don't you know that you need to pull out of that and go someplace else? But no, he has to lose $1 million, and then he loses another $1 million, and then he keeps losing millions of dollars, and he don't do nothing about it. He's stupid. He got problems. That's the way I was thinking as a child. I kid you not, because that was my mindset. You had to be stupid to lose millions of dollars. Now, I know people lose millions of dollars all the time because of bad investments. Ladies and gentlemen, the one thing I don't do is I don't spend just to be spending. I don't buy things just to be buying it. Yet, I have enough food to last for the next 3 months without having to ration anything. I can go 7 months if I rationed. Then in a couple of days, I'm about to go stock up on some more, and I'm going to advise all of you, because of what's coming, what's happening now, go and stock up on food. I know you heard about the FEMA colors and the FEMA camps and all of that stuff, and how they're going to be going through homes and taking people's food. I know you heard about that. But just in case they don't, get what you need to right now so you can survive up until that point. Because that's the point. You need to survive up until that point. Literally. Okay, now we're going to talk about credits, y'all. Sorry to take y'all ring around the rosy, pocket full of... Okay. If only people knew about that song. Ladies and gentlemen, that is not... There is nothing pleasant about that song. That is not a children's song. Go ahead. I know where the song comes from. I know where it comes from. But the idea behind the song... Whoo-wee! All right, ladies and gentlemen, we're going to do it again because we need to bring you guys from the very beginning. We need to help you guys. You know what? We're not going to go anyplace this time. Like I said, we got 3 weeks of this that we're going to be talking about nothing but tax credits. So let's talk. Okay? Now, I am going to have my music in the background. Well, yeah, technically I have to, when I'm using the iHeart program and the commercials come on because I skip a song, I have to delete it and install it back. It's a little hassle, but I'm willing to go through that hassle. We got white lines running through my mind. This is Grandmaster Flash and the Furious Five. I don't know why they're furious. You know, I ain't did nothing to them. But apparently they're mad. And they really shouldn't be mad. But this is Grandmaster. Now, you know what this right here? I can't watch this too long. And the reason why I can't watch this too long, because the 3D effects of this, literally, I found myself when I was first watching this moving out of the way of some of these asteroids. I'm not joking. It literally had the 3D effect with the screen and the glasses I had on. And so I was literally moving out of the way because of that. All I can tell you is, yes, whoever came up with that design right there did a very good job. All right, ladies and gentlemen, here we are. Let's talk tax credits. 1 minute and 2 seconds. 1 minute and 1 hour, 2 minutes into it. Hey, Grand, give me 1 second. Grandmaster Melly Mel, ladies and gentlemen. I'm going to put you guys on pause. I have to go and shut down some windows. I don't want nobody looking in while I'm talking to y'all. They be looking and staring, and I just get tired of the drivers coming by and just looking and staring. I don't need them looking and staring at me every 5 seconds. 1 second. Okay, ladies and gentlemen. The first thing I have to do is I have to prove a couple of points. Hey, I'm actually glad this planet is here. You guys know what planet this is, don't you? Well, see, up here you see the polar cap? The reason why it's a polar cap, because the sun is over here. See? Sun. So the sun hits directly here, here, here. But because this is further away from the sun, see how dark it is up there? The water freezes. Same thing down here. The water freezes, furthest point from the earth. So the earth used to have a blanket of water. That's where you hear about the firmament in the King James Version. The other Bibles talk about an expanse of water. The separation of the waters. If you look at, I believe it's verse 2 through 5, it talks about the separation of the waters and the dividing of the waters, so that there was a division between the land and the waters. People think that oceans were created. No, there were no oceans back then. Everything was an ocean. It was all covered by molten lava and boiling water. Okay? It was hell! No. Anyway, and they separated the waters so that there was a blanket of water covering the earth, which kept the earth one constant temperature. Why do you think we have an ozone layer? We have layers in our atmosphere. Well, one of them was a water layer. Do the research. You'll see scientists have already confirmed that this to be a fact. Okay? Scientists confirmed about the water layer that used to cover the earth, the thick water layer. And during the flood, he let it fall. And the waters, when they fell, the parts furthest away from the sun, instantaneous freezing. That's why you found animals like woolly mammoths. You notice you never found a woolly mammoth in the middle of the desert with food stuck in its mouth. Always in the northern hemispheres or the southern hemispheres, but never in the equator have you found anybody with nothing stuck in their mouth talking about it was stuck in their mouth when they died. There was an ice age. The ice age is always in a northern or a southern hemisphere land. Go ahead. Take a look. Do the science. I've never checked it. I guarantee you that's the way it is. I dare anybody to prove me wrong on that one. Well, anyway. Enough about that. In 1998, I was incarcerated. And I made it a point to tell myself that I was going to improve myself. Wasn't just going to sit there and just do somebody's stupid time. I was going to make improvements on myself, while at the same time challenging the courts. And during that time, I started doing some research, started paying attention more to the news, more to finances, and started focusing on things. Now, I've always been interested in stocks and bonds, not so much stocks, more so bonds. Not so much trading. I could care less about trading. Okay, I don't have the patience for trading. And so what I did was, upon the release from that place, I had already made it a point that I was going to help people. And so I started. Now, there was no YouTube like there's YouTube now, so didn't have that type of help. I was helping people around me. And I helped 18 different people with their credit. 17 of them we were able to finish and get their credit taken care of. But, ladies and gentlemen, that's a lot of people. And for one person to handle 18 people by himself, that was tiring. So what I did is I did a video. And I put it on YouTube because my best friend was in a situation where I had to help him because they were foreclosing on a property that he had an interest in. And he wasn't capable of handling that type of debt being on his credit report. And so I did tell him, I said, I will make it go away. I didn't know how I was going to make it go away, but I was going to make that debt go away. And so I was writing to banks. I already knew how to get rid of debt because I just told you I'd already corrected the debt of so many people. And so, but I had to figure out how to get rid of a mortgage debt because I never had a mortgage issue to get rid of a mortgage debt. I understood how mortgages purportedly worked, but how to make that debt go away was the issue. So I started watching Winston Shrout. I didn't know about Winston Shrout. Sorry. Hey, what up, Will? Winston was doing videos, and then there was a guy, his name was Sam Davis. I haven't heard from Sam Davis. I've seen a couple of videos of his, but he's not, not the same. Many of us who did videos back in the day were not the same persons. We've evolved, gone on to other things. But unlike most people, you see, I'm still here, and you got individuals like Rob Ryder. I don't know if the Bays, Jonah Bay, and you know what? I apologize. Yusuf L. Man, I don't know why I can never remember his name when I'm trying to remember his name. You got Yusuf L. and Jonah Bay. I know that they're still helping people. Doug Christie, I haven't heard anything from Doug. And Riddle, haven't heard anything from Riddle. I don't know. I think that Mr. Tim Turner, I know that he should be around by now because it has been 2012 until 2022. It's been 10 years, so he should be around by now, but I haven't heard anything from Tim either. These were the people who I appreciated. I give them their credit because they were trying to help people. Yeah, I know some of them charged people, and I criticized them back then. I told people when I did seminars, I did my last seminar in New York, but I told people when I did seminars that I would only charge people for the venue and for my time, but for nothing else. You were not there to support my lifestyle. Okay? Just not going to happen. But as I promised people in this whole process that I would dedicate my time if they helped me, not now, because I'm not doing donations now, but when I was doing donations, if people helped me, that I would put out information that would help everyone. And I definitely believe that I've done that over the last 4 months. If I haven't, then I can't help you. You don't know what information is and you don't know what help is, so I can't help you. Well, ladies and gentlemen, in helping people with their debt, I had to figure out what was the best way to help people. So we started the Legal Redress Commission. Well, I started the Legal Redress Commission officially in 1997. technically 1998 is when I officially came up with the name, but the idea was 1997. It was called the Legal Redress Commission because the gentleman showed me the redress right of the First Amendment. The gentleman, his name was Richard Fuller, who is deceased by now. But Richard said, hey, I got something I want to show you, and I know you'll do something with this. And he was absolutely right. So the Redress Commission, but still the Redress Commission did not help people to the extent I wanted to help people. So I had to figure out how could I better help people. So in 2012, I told people we were putting together the Securities Acquisition Trust Commission. And while I was in New Mexico, I set up a member benefit organization, an MBO, under the name of SatCom, the Securities Acquisition Trust Commission. That was 2012, ladies and gentlemen. That organization was supposed to create securities. Why? I didn't know how to create a security back in 2012. I knew I could, I just didn't know how. And so from 2012 to 2016, the idea was focus on creating securities. Look, securities in my mind couldn't be hard because companies create securities all the time. It's under the Securities Exchange Act and under the other Securities Act of the 1930s. However, they make it difficult for people because of the terminology, but it is not difficult. The only problem, I want y'all to hear this, the only problem is I needed to back the securities with something. Well, of course, I'd already figured I'd back it with my full faith and credit, but that wasn't good enough. But I needed to have something tangible to back them with. So, we created these contracts. These contracts, everybody assumed it was designed to get them out of the system. The contracts weren't designed to get them out of the system. The contracts were designed to create a security. That's why it's called the Securities Acquisition Trust Commission and the Securities Investment Trust Commission. The contract was SITCOM and SATCOM. That's what the acronym stands for. The contract was designed to create a security for people where they invested in their own security, and that's what they did, and to give it value, we placed it on a public record. Now remember, it was a trust, but to give it value, we placed it on a public record so that we could get the state seal. And we attached a birth certificate which already had 3 different seals on it because the seals are backed by the full faith and credit of that entity. So we had to give the SatPacks value. That was a temporary value, but value nonetheless. Full faith and credit. Ladies and gentlemen, we tried to explain that to people, but they didn't get it. So right after we created that value, Bradley Christopher Stark did something. He had a contract because we've been trying to figure out how do we enforce our contracts. We were writing contracts between us and government and we couldn't enforce them. They were ignoring us in the court. So how do we enforce our contracts? Arbitration clause. Bradley Christopher Stark, you go, boy. So we added an arbitration clause, created contracts, but what I did before I did a single contract and put it out there for any of y'all to do, I sent out all of my contracts. 17 different parties. Contracts. Arbitration clause. You know, nobody responded, except for the Attorney General for the United States. They actually said they're going to get back with me. They never did, but they said they were going to get back with me, which means acceptance. Ladies and gentlemen, as we showed you, the Attorney General, if they receive a complaint, and mine and all the other SatPacks were complaints, if they receive a complaint, they must respond. Well, they didn't respond. So we had arbitrations. By the way, ladies and gentlemen, let me explain, because some of you guys have had arbitrations and you've had the court say that SitCom Arbitration Association is not a valid arbitration association. Let me help you out. We're not a valid arbitration association under state law, but we're not set up under state law. We're not registered under any state law. We are an arbitration association under federal law. No arbitrations are done under state law. All of our arbitrations are done under federal law. So when they make that statement, you must pay attention to what's being said. Because I keep hearing them say Valid Arbitration Association. Well, SitCom Arbitration Association, go back and listen to the first videos when we were first setting it up. We told you each of the arbitrations will be done by an independent arbitrator. Go back and look at Bradley Christopher Stark. The young lady he had do his arbitration was a private individual. Okay? The young lady he had do his arbitration was a private individual. Just so that you guys will know, because sometimes people don't understand. She wasn't an association. She was just an arbitrator chosen by the parties. Every single SatPack that's ever been done, the arbitrator is a private arbitrator chosen by the parties. Just that simple. Nothing more, no more information necessary. Once the arbitration award is issued, what gives the arbitration award value? Does anybody know? Ladies and gentlemen, arbitration award receives value if the person waits 90 days past the issuance of the award. 90 days, no more, no less. 90 days. Look at Section 12 of the Federal Arbitration Act. 3 months. That's all they have to do is wait 3 months. Hold on. Let me show you guys something, because sometimes...
Well, I did this and I did that, and they told me that I was full of...
And they were right. You are full of something. I don't think it's this one. This is from yesterday, so this ain't it. Hold on. Let's see. I think it might be this one. I'm gonna have to go back there. No, it ain't that. It ain't that. It is the first one. Sorry. It ain't this one. It ain't that one. It's this one. I'm looking for a particular website. Not there. Not there. Right here. This is the site I'm looking for. I want to show you guys something. Let me show you this site. Let me show you something. This site is by this young lady right here. I believe she is a lawyer. She explains about arbitration. She gives you her spiel and what she thinks and so forth. And I perused through some of this. Some of the information is basic and simple information that even a caveman can pick up on, which means some of you all will probably have some difficulties. But nonetheless. Anyway, ladies and gentlemen, I want you to pay attention to the section I have highlighted. Confirming an arbitration award. What papers does the opposing party file to oppose the application? Okay, we are not looking for that. We're looking for this. Confirming an arbitration award what are the time limits for filing an application? Section 9 of the Federal Arbitration Act requires an arbitration or an application for confirmation of arbitration to be brought within 1 year's time after the award is made. Confirming an arbitration award. What can the opposing party move to do to vacate, modify, or correct the award? Or when, sorry. Can the opposing party do that? Section 10 says yes. That depends on when a party files its application to confirm the award. Hold on. Ladies and gentlemen, I never read this from this woman. I understood the act. While a party applying to confirm an award has 1 year to make an application, a party that wants to vacate the award, modify, or correct has to assert its grounds within 3 months. If the party seeking to confirm the award, or confirm the application, or confirm the award, makes its application to the court after 3 months have elapsed, then the opposing party cannot, as a matter of law, assert Section 10 and 11 as grounds for vacating. Do not sit up here and tell me that I didn't know what I was talking about when I told all of you. Wait 90 days, then go and seek confirmation. Because if nobody opposes the award within 90 days, no one can. This is the case. What site is this? I don't know. It takes too long to show you guys all of that. I got people sitting up here challenging me saying, well, the court said this and the court said that. Ladies and gentlemen, I don't care what the court said. The court contradicts itself all the time. You need to do your research. You need to know what you're doing. You need to know how to appeal. Okay? The key procedural requirements for confirming an award are: the party seeking to confirm must apply for it within 1 year after it is made, and the court must grant confirmation unless the award is vacated, modified, or corrected. Ladies and gentlemen, according to sections 10 and 11 of the FAA, okay, that's the law. Just that simple. It's not that hard. So we're going to go to F and G. Thereupon, the court must grant such an award unless the award is vacated, modified, or corrected under sections 10 and 11. That's the only reason. They cannot do it outside of section 10 and 11. But under 10, a motion to vacate, can't do a motion for sanctions. Can't do a motion for declaratory judgment. You can only do a motion to vacate. Go back and read it. And the code is specific. Okay, it gives limitations and they have to stick within those limits. They can't make up anything else. Ladies and gentlemen, she does an okay job explaining the Federal Arbitration Act. Okay? Now, under the Federal Arbitration Act, judgment on an award shall have the same force and effect in all aspects and respects as that of a court judgment. That's if you're getting it confirmed. We're getting there. But as I told some of you, you don't have to get your award confirmed. You now have an arbitration award, so you convert it to a FDCPA claim, Fair Debt Collection Practices Act. What does that say? That if somebody owes you for a debt, you have the right to send them a notice. In fact, you must send them a notice. So the arbitration award letting the other person know that they must pay and giving them the time to pay is your notice of a debt. Okay? And it lets them know that this is an attempt to collect a debt. Just that simple. When they receive that award and they don't pay, all you have to wait is 6 months. If you wait 6 months, hold on. Okay, sending a debtor a 1099-C, you need the B section of that form, after 180 days of default. Once you do that, pay attention, it is the credit card issuer's way of taking a loss. Well, actually, ladies and gentlemen, they don't take actually a loss. By recording it as a loss, they receive a credit. That's why they're called the creditors. Okay? Now, sorry, that's my yawning. You may file a 1099-C only if you meet your Form 1099-A filing requirements. You may file, pay attention, a 1099-C, so a 1099-C and the 1099-A go hand in hand. Shh! Nobody told you that before, did they? Don't worry about it. Don't worry about it. I don't care if you did know. You may file a 1099-C only. You will meet your Form 1099 filing requirements for the debtor. Specific instruction for Form 1099-C later. So, ladies and gentlemen, this is the IRS.gov. This is what they are saying regarding 1099-C and 1099-A. And guess who they're talking to? They're talking to the creditor, the banks. So what we're going to do is we're going to open this in another window because it's taking its time. taking its sweet time. And I don't want it to be taking its time because I ain't gave it permission to take its time. Okay. Ladies and gentlemen, because you waited 6 months, hold on. Because you waited 6 months, you can elect to write off that debt. I downloaded it twice. I'm sorry. So if you elect to write off that debt at that very moment that you elect to write off that debt, I downloaded it 3 times. Wasn't trying to do that. If you elect to write off that debt, it becomes an automatic tax credit. But because the government gave you that automatic tax credit, you must notify the government that you're writing it off, and you must notify that borrower or that person who owes you, known as the debtor, that you wrote that junk off. Ladies and gentlemen, our next video that we do on taxes, which will probably be done tomorrow, we are going to cover this form. Hold on, let me show you how many pages it is. We're going to go, like I said, the next 3 weeks is all we're going to talk about. 6 pages. We're going to cover from A to Z. And then the very next video after that, we're going to pull up a 1099A and a 1099C. And then we're going to talk about the other forms that go with that. Because the SatPacks are evidences of debt. Go back and look and notice that you're letting the government know you want access to your account. You have an interest in that account. Okay, hold on. Let me show you, because I'm just thinking about it now because I hadn't thought about it before. I'm just going to do that right there. Are personal loans taxable or considered income? They're generally unsecured, and loans that don't require an asset to borrow money, secured loans like auto loans and mortgages, use collateral. Okay, you have an interest in collateral. Okay, you have an interest in the collateral. So because you have, do you pay taxes on collateral? Okay, that's the first question. I'm interested in that. So guess what we're going to do? We're going to find out. Generally speaking, paying back a loan and receiving the collateral back is not a taxable event. Well, we're not generally speaking. Do you see how they use that word right there? General Lee. General Lee is dead, y'all. Okay, General Lee is dead. Recourse, non-recourse debt. Non-recourse debt loan does not allow the lender to pursue anything other than the collateral. For example, if a borrower defaults on a non-recourse home, okay. Wait a minute, hold up, wait a minute, hold up. Tick-tock, tick, this is IRS.gov. A non-recourse home. Anybody know what a non-recourse home is? I believe that each one of your houses qualify as non-recourse loans. I believe that all of your homes qualify as non-recourse loans. I didn't ask you to go down there. There are 2 types of debt, recourse and non-recourse. A recourse debt holds the borrower personally liable. All other debts are considered non-recourse. Generally, in general, recourse debt loans allow a lender to collect what is owed for the debt even after they've taken the collateral. Ladies and gentlemen, all of your homes are non-recourse loans. Why? Because they cannot, pay attention, collect on the debt after they've taken the collateral, because the collateral was put up in exchange as a guarantee for repayment of the loan. Okay, there is no such thing. They created this recourse. Okay, a non-recourse debt loan does not allow the lender to pursue anything other than the collateral. For example, if the borrower defaults on a non-recourse home loan, the bank can only foreclose on the home. The bank generally cannot take further legal actions to collect money that is owed on the debt. Whether the debt is recourse or non-recourse may vary from state to state, depending on state laws. They created laws so that they can keep coming after you. Because remember, the government is concerned about debts and going after them, and you guys are not writing it off. So they're punishing you for it. You're supposed to be writing off your debts, but because you're not writing it off, you are bringing up the public debt. And so they're punishing you for not writing off your debts. I'm actually glad I went here. So I'm going to keep this page because I need it. Okay, not there. We're going to go here. And with that being said, we're going to go back. Now, that's a snapshot of a page. That's not the actual IRS page, even though we went to the IRS website for that. I was interested because it talked about non-recourse. Ladies and gentlemen, pay attention. It is not non-recourse. It is without recourse, because you guys are not signing those mortgages without recourse. The banks are signing it without recourse. Go back and look at the signature on the back. If they sign it without recourse, they cannot take that home and then collect on your taxes. They are signing it without recourse. By the way, if you get a copy of your loan and it has paid to the order of without recourse on it, and it has the bank's name on it, that's proof that that loan was converted into a security. That's proof that that note was converted into a security, and if it was converted into a security, it's no longer a mortgage. Don't take my word for it. Okay? Wait, hold on. Which one do I have open? We'll do this one right here. And then that's going to be it, because I'm literally out of it. More than likely, I will load this up tomorrow. Okay? It is 8:04, and I really am out of it. So gotta wait for it to catch up to me. I apologize. It's taking a long time. Oh, there it is. Okay. Come on now. The mortgage, I'm still typing it. It ain't following me. Dang it, I wasn't even looking at the screen. Okay, if the mortgage, I know I messed up mortgage. Oh, look at what it's still doing. God, get out of here. And like I said, come on, one more. Yeah, see, I know that they're messing with the system now. Because you notice, ain't nowhere in the world that's supposed to be happening. Ain't no voice recognition on or nothing. So I know they're messing with it. But anyway, if the... Matter of fact, I'm going to put y'all on pause. Okay, I put, if the mortgage is converted into a security, it's no longer a secured debt. That's the first thing I put. It's not the actual statement, because I don't remember what the actual statement is. But I do know that's the actual principle. Okay? So let's find out what we get first. The obligation secured by the mortgage is still a debt. So for recovery of any debt, enforcement of any right secured by the mortgage. Okay, the debt in which a mortgage or lien encompasses are held. This is so because the mortgage is merely a security for a debt and it is not the debt itself. Okay. In any event, it is a new debt or obligation which the mortgage secures. Not looking that... sorry. I said mortgage. Sorry. It is not the mortgage. Sorry. Come on now. NOTE. Sorry. Because it's the note they do pay to the order of without recourse. That's what converts it to a security. Alright. I knew the keyword search, even though the keyword search, because I have it in quotations. That's why I can't find it in the keyword search. Yeah, somebody is messing with the system because I done clicked parallel search 4 times already. That's why you see it had me downloading that form 5 or 6 times. Whatever. A creditor can enforce a note as an unsecured debt without security interest. Nobody cares about that. Converting the JBM debt into equity, Act satisfies its obligation under note. Thus, JBM security interest is no longer enforceable. Pay attention. Pay attention. By converting JMB's debt into equity, converting it into a stock. See, the note was extinguished when the underlying obligation was converted into a common stock. Shh. When you convert the note, it satisfies the obligation under 2006 note, and thus the security interest is no longer enforceable. They can no longer foreclose on the home. Ladies and gentlemen, yes, I've known of this stuff. This stuff is here inside this noggin of mine. Those of you who stay to the end, hey, do your research on this. Converting of that note removes it from being a security as far as where it can be used as security for a loan. If he failed to do so, the in veritu note prescribed that when the hand note would nonetheless remain a valid obligation, it would no longer be secured by a mortgage and would simply reflect an unsecured debt. Note, unsecured legally, but unsecured practically in the sense, not unsecured legally, but unsecured practically in the sense that the security is virtually worthless, being the pledge of this prescribed note. Yeah, the collateral. The collateral is the pledge of the prescribed note. And that's the same one. All too often, lenders neglect or forgot or were not advised to obtain a written acknowledgement every 5 years. Ladies and gentlemen, I would definitely read this because I didn't know about no every 5 years. So let's find out. It says all too often they need to get an acknowledgement. What type of acknowledgement does a lender have to get every 5 years? Nobody told me. Morrell Tire Company versus J.W. Harpin Incorporated. I ain't never heard no J.W. Harpin. Morrell Tire Company? Maybe heard of them, but don't know. The Narrator note itself then can prescribe, and being a demand note, the prescriptive period of the Narrator note is 5 years, because it has to be one of these notes. I don't know this term. Never heard of this term. So let's go ahead and Google. Because not every state's going to have this. But hold on. A paragraph is a signature by a notary on the evidence of an obligation. Typically, a collateral mortgage note, to identify the note with the collateral mortgage securing the note by paragraphing the note, and the notary binds and identifies the note with the act of mortgage. Really? Ladies and gentlemen, watch this. I'm going to do something because I think I understand exactly what's going on here. And I'm not sure because I haven't seen this before. Now, Louisiana is the main state that has this, and they have to do this every 5 years for Louisiana. But I put California there, and I wanted to see if this was also in California. And I know LSU, Louisiana State University, so I know that, but I'm looking for a place other than Louisiana. And I was thinking it was California because it looks like this is the practice where the notary is brought in. I'm interested in how this applies to California, but everything seems to be coming up. Hold on. All right, I see how y'all want to play. I know there are going to be people going to say, no, the reason for it, and that's okay. I understand that some of you already may know about this, but as I told you prior to today, I had not seen that word. And I'm trying to formulate an understanding and an idea behind it on how to use it to one's advantage. So I am trying to see if this is also something that is used in other states besides Louisiana, because so far Louisiana is the only one that comes up, and that can't be. Okay, that is impossible that it's only one state, because the case law that we just read, now this is Bankers Trust Company of California, in a petition of urged that the failure to insert language in the act of subordination in favor of UCFC results in an ineffective. Okay, but about our paraphrase regulations, pararegs. Pararegs are summaries of law and subject to California. Ladies and gentlemen, that's what I thought. Para requirements in Louisiana. So even though this, I'm going to say must include California, because I think that it must include California. So we're going to go here because I do believe that it applies not just to Louisiana, but I think it also applies to California. But it says, I ran across the Latin phrase on the signature page of a note from Louisiana. Specifically, the wording was this. Okay, I'm looking for, like I said, California, and this is the one that comes up. And I do know that it's in California. How do I know it's in California? Because California has laws dealing with the paraphrasing. It's not just Louisiana. See? Do every promissory note need to be notarized in California? Okay? Just like in Louisiana, their notes are notarized. This is a notarized note, ladies and gentlemen. That's all that practice and procedure is. It is a notarized note. But Louisiana, their law says it has to be authenticated every 5 years. Secures mortgage and property. They do an affidavit of lost note, and that's the legal term that legal procedure they came up with. I don't know what state this is. This is California, and they're talking about this, i.e. notarized with identification. So it is California. It is every state. That's where I was heading, ladies and gentlemen. I figured this applied to every single state. Now, this is they called it a kind of a paraphrase laws. And this little term is designed to throw me off and you off at the same time. So let's go here to this court. And then what I'm going to do is I'm going to take this and put it in case text. Then when I do the next video, when we go through that document with the IRS, because we're still going to be talking about, they go hand in hand. So we're still going to be talking about the credits, and we're going to be talking about this note thing to help our people who are struggling and going through foreclosure. Okay? It is absolutely necessary. And which said note is paraphrased ne variator for identification with an act of mortgage dated August 13, 1982 and passed before Roy M. blah, 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 blah. Okay? So I am positively confident, positively certain that this act involves all mortgages for which a notary is called to witness the signature on the mortgage. Each one of you goes through this at closing. It's just states like California doesn't use that word. Louisiana uses that word. We're talking about a process. If the process is not done correctly, ladies and gentlemen, but remember, we came across this, and I'm going to read across this tomorrow, and we're going to do a video on it tomorrow. However, we came across this from this case right here. And, sorry, you got to get rid of that so I can get rid of that. So I can move. It's prescribed as being a demand note for a prescriptive period for 5 years. For that reason, until recently, it has been customary practice to have the mortgager sign the written acknowledgement on the note, notarized note, within 5 years after execution. Oh, they had to sign it within 5 years of execution, not that they had to do it every 5 years for the note. And thereafter, and thereafter to repeat the procedure within 5-year periods to prevent prescriptions from running. If he failed to do so, the notarized note prescribed, and while the hand note would nonetheless remain a valid obligation, it would no longer be secured by the mortgage and would simply reflect an unsecured debt. Now, they said this was until recently, so they changed that law because they needed to make it easier for banks to foreclose on people's property. Okay? Note, an unsecured legally, but secured practically, in the sense that the security is virtually worthless, being a pledge of the prescribed note. All too often, lenders neglect or forgot or were not advised to obtain a written acknowledgement every 5 years and found themselves holding prescribed mortgage notes. As a result, Louisiana legislature enacted a special statute in 1970 to remedy the problem of prescription on notes, such as the Navarrete note, as it is used in collateral mortgages. Okay, I don't know how this applies in your state. I will read this tomorrow because I am too tired to go through this now. But I think, and this is why I was still focused on this, and this is why I said some people are going to, say this and that about explaining this. No, I didn't need that because I'm going at an angle. If this is applicable to every single state in a note that is signed by a notary, we need to find a loophole and we need to attack the loophole. That's what I do. I look for loopholes. Thank you, Maxine. Sorry, Maxine Waters and I were right on point when she was telling me about loopholes. Every law has a loophole. I look for loopholes. And the loophole here is the notarization. Every state has a notarization of the note, that the note must have an authenticated signature of you, which means it must be notarized. Must have the seal of the notary on the note. If it has the seal of the notary on the note, most states will be like Louisiana, saying that it must be redone this amount of times. So that's what we'll be doing tomorrow. We'll be covering that. All right, I got some other things I need to do in the morning. But after I do that, I'll do another video. This video will be up in the morning. That will be the job. Matter of fact, I just ran down the energy in the battery because I just charged it. But I've been on this computer since 8 o'clock this morning without turning it off. Well, I think I turned it off once to restart it. But other than that, I've been on this computer since 8 o'clock this morning. So I don't want to hear it. Got enough energy to take care of things when I need to take care of things. And I'll start putting up the solar panels. But if I put up the solar panels, I have to put up the cameras at the same time. So that's going to be some work. So I'll start putting up the cameras. As a matter of fact, I'll start putting up the cameras tomorrow. Matter of fact, I will make it a point to start putting up the cameras tomorrow. I will cover all the angles, get the ladder out, and do that and this at the same time. All right. Well, I got a camera system. I think it's a 12 unit camera system. Need to cover every angle. Northeast, southwest, northeast, southwest, southeast. Need to cover every angle because you know how people will sneak and move this and move that. So I got to make sure every angle is covered so that nobody be sneaking and moving no cameras, because I had a guy tell me the police came on his property with a warrant and they started moving cameras, y'all. Moving cameras. Don't touch my security. That's for my protection. Second Amendment gives me protection rights. Don't touch my security. That's not only for my protection, but that's part of my property. You ain't got no business touching my property. I have a right to be secure in my property and my possessions. That's part of that security right. What you doing? Get your hands off my camera. No, the warrant didn't say nothing about you touching my cameras and moving them out of position. No, you put them right back where they were. I got a right to be secure in my own possession and home. You don't get to interfere with that. No court can order that without due process of law. All you got is a warrant. You ain't got no warrant to be messing with my security system. You follow me? All right, ladies and gentlemen, I gotta go. This is almost 2-hour video. Just talking to you guys about helping you guys. Hey, I think the information was valuable. All right, we'll talk more about tax credits tomorrow. For 3 weeks, we're going to talk about tax credits, everyone. So I hope you're ready. All right, gotta go. Adios, y'all.